very happy to be here. I think I might be the only native Dubliner speaking in the conference, so I just want to reiterate all of the welcomes and thank yous to all of our guests who've travelled from Palestine and Israel and down the road from up north and elsewhere to be with us, and to thank the IPSC for bringing us all together here in Liberty Hall. I don't know how many events I've been to here over the years, but I've never spoken here before, so I'm also happy for that opportunity, especially this weekend as we remember and mark the execution of James Connolly. I think the first time I spoke at an IPSC event in Dublin was 10 years ago. It was in 2008, and we were at that point talking about the 60th anniversary of the Nakba. I was still living in Palestine at the time. I'd been working with Al-Haq and at that time doing a project with Eitan Bronstein, who's here, and Zochrot on the Latroon villages that were an important strategic site in 1948, but managed to survive the Nakba, but were then destroyed at the start of the occupation in 1967. And so we'd done a report and a documentary and a campaign around that issue. People from those villages that had been demolished were displaced in Ramallah and in Jordan and Canada and elsewhere. And at that point, we were talking about 40 years of occupation, 60 years since the Nakba, and obviously 10 years on, a lot of the fundamental issues of injustice, the things that international law is trying to address are still fundamentally the same, even though a lot has obviously happened in those 10 years since. We heard from Haneen yesterday about the increasing kind of repression and repressive laws in Israel under this, probably the most overtly racist and far-right government that we've had over the last, or series of coalitions over the last 10 years. But also, like we heard from Omar, some of the successes in building the global solidarity movement and in mobilizing people, bringing about successes in the boycott and divestments movement, at least so far, if not in the sanctions movement, which is at the higher end of the spectrum of international law. And so when Kev had asked me to speak, I said, "What do you want me to talk about?" And he said, "Well, if you could talk about international law, but not in a boring lawyery way." And so I'll try and do that as best I can, but apologies in advance if I don't manage it. Like 1948, when we think about the Nakba and everything that was happening in the world at that time, it was really a kind of remarkable moment of flux beyond just the Nakba and the creation of Israel. You had the initiation of formal apartheid in South Africa, but you also had the adoption of the Universal Declaration of Human Rights that same year, and so we're still, I think, living with a lot of the contradictions and the disconnects between those things. The commitment to a universal vision of human rights on one hand and global justice, but the kind of ongoing systemic inequalities and forms of repression. And so I suppose my work in and around international law is trying to think about how international law can help us to at least respond to some of those injustices. There is a sense, I think, that we all have that obviously justice is on the side of the Palestinians, but also that the rules of international law are on the side of the Palestinians. We have, endless fact-finding missions and human rights reports and so on, documenting the violations, the war crimes and all the rest, but the reality is obviously we're still very far away from justice, and so why is that? So I'll try and just talk a little bit about some of the different concepts and categories of international law, humanitarian law and occupation law as one, what international law says about colonialism, what it says about apartheid. If I have time, I'll say a little bit about the International Criminal Court as well. So, but I suppose just one general point as an overarching thing to note from the start is that, when we see what's written in the letter of the law, we have to remember there is this distinction between what we'd call the content of international law and its form, right? So what that means is that, the content of the rules may say one thing, but the form, which means the structures, the institutions and the power dynamics that the application of the law gets filtered through, that means that in many cases the content can be diluted or distorted or sometimes even simply disregarded. And so that is a major challenge for lawyers and for activists working on these issues. The prohibition, for example, on the military use of force to bomb another country or another territory is one of the clearest rules of international law that is illegal. But we've so many examples of, if we think of Bush and Blair saying, well, we need to do this for humanitarian reasons in Iraq. We have Israel saying, well, we need to do this to defend ourselves from this territory that we've laid under siege for so long. We have, most recently Trump and Macron saying that we need to do this to make a point, some kind of symbolic point about how atrocity by chemical weapons is somehow worse than atrocity by conventional weapons. And so all these various different justifications for invasion and conquest and bombing that muddy the water somewhat, and you have imperial powers like the US and the UK and Israel and their lawyers devoting a lot of time and resources to coming up with legal justifications and arguments that try to twist the interpretations of the law in their favour. And so, we have these power dynamics to be wary of, as well as just the general difficulties of finding the appropriate court or institution or forum to enforce the law in the first place. So the traditional kind of mainstream international law analysis for a long time on Palestine was around international humanitarian law and occupation law, thinking about the occupation in the post-1967 war context. The law of humanitarian law, or the law of occupation, does give us important rules about what war crimes are, standards that illustrate some of the injustices of the practices that we see in the occupied territories, some of which also does allow us to challenge the structural nature of the situation with settlement of occupied territory, rules against appropriation of land or extraction of resources, all of these things being very clearly illegal. But for the most part, humanitarian law standards really focus on individual incidents, attacks, and tend to kind of frame the situation as individualized or disconnected violations against a particular person in a particular instance, rather than thinking about the whole system of occupation as a form of structural violence against a whole people. And so we have, rules about who you can attack, who you can't attack, what standards political prisoners or prisoners should be kept under, what type of access the occupied territories should have to essential medical supplies, all of these kind of things. And Israel's obviously breaking all of these rules, but at the same time, if Israel was to turn around tomorrow and say, okay, now we're going to implement those rules, we'd still have an occupation. It would just be a slightly less inhumane occupation. And so there is a limitation there in terms of what occupation law can do in addressing the deeper root causes. And we might assume that we might hear people talking about the occupation as illegal, or assume that the occupation has to be illegal because of the nature of it, but actually international humanitarian law doesn't really regulate for that. It just takes it as an assumption that occupations can happen after a war, that it would be a temporary, a transitional situation, and then sovereignty would be returned to the occupied population and things would progress from there. It never imagined or legislated for the fact that an occupation could go on for 50 years or more. So the UN Special Rapporteur at the moment, Michael Lynk, has been trying to develop some thinking on this to make a clear test and argument to show that the occupation is illegal. And I can share his documents on that if people are interested. But essentially, he's making an argument that at this point we have to think about the occupation as illegal. But still, at the same time, we're left with the same limitation on that we're only talking about post-1967 occupied territories. Even if we talked about the occupation being illegal, that's only really a starting point for getting more at the core of the Israeli state's system of control over the Palestinian population as a whole. Because as we heard yesterday, it was 38% was the figure mentioned in terms of what the occupied territories make up of the Palestinian population as a whole, right? So that's been the traditional focus of international law, the occupation and practices within that. There has been a lot of thinking and work done the last 10 years trying to move towards a more systemic analysis and think about how colonialism or apartheid as legal concepts rather than specifically and distinct from historical and political analytic frames, how they can be used to understand and analyse and challenge the Israeli regime of control. So settler colonialism, we've heard a lot about. There's been a revival in scholarship and thinking and thought around settler colonialism and decolonisation, which I think is really important in historicising colonisation of Palestine, thinking about it as a process that began long before 1948. We talk about, obviously the ongoing Nakba, and the Nakba not being just an event that happened as a once-off thing in 1948, but it is an ongoing structure and process. But it also didn't just start in 1948. It's the settler colonialism as a framework allows us to think about that and understand that, and so has been really important, I think, in shaping people's thinking and understanding of the conflict. But at the same time, within international law, colonialism is somewhat problematic as a legal concept, because international law essentially functioned since the 16th century even as a way to facilitate European expansion and imperialism, and international law was very much part of the colonial project. Colonialism was lawful and facilitated by international law really up until the late 1950s. And so even when we think about the Universal Declaration of Human Rights in 1948 being a universal declaration, at that time you had some of the main states involved in writing that declaration, like Britain and France, talking about universal human rights, but at the same time coming up with legal justifications to say these rights aren't valid in the colonies and don't actually apply to the colonised territories. So it's only really since 1960 that colonialism has been prohibited under international law. There was a series once all the third world states became independent and entered the UN system and pushed forward the agenda of anti-colonial legislation in the UN. Since 1960, colonialism has been prohibited. But essentially what that does is legitimise or set in stone processes of settler colonialism that had been in place before 1960, right? So, and there was a lot of concern at the time among the likes of the United States and Australia and Canada that we don't want this prohibition of colonialism to apply to us internally, to our control over Indigenous peoples. And so it was a very clear separation of its only colonialism beyond existing borders in 1960, which means that that doesn't allow us to really fundamentally challenge the Nakba and the State of Israel as a colonial entity. It only really, again, allows us to challenge Israeli colonialism in the occupied territories beyond the Green Line. So we have a limitation there. So what I've been working on and writing about a lot for the last 10 years is the idea of the prohibition of apartheid in international law as the most useful and holistic concept that we have in international law to allow us to understand and challenge that holistic regime of control over the Palestinians, not just in the occupied territories, but also inside Israel and in exile, and allows us to connect the dots between those fragmented parts of territory and people and the overarching legal and constitutional system in Israel, which is obviously an overarching regime that governs the Palestinians wherever they are, whether it's internally within the State of Israel being discriminated against there, whether it's being ruled by military government in the West Bank or Gaza, or whether it's being prevented from return by the citizenship and immigration laws. And so I was involved in various studies with South African lawyers and research councils, with John Dugard, who used to be the UN Special Rapporteur, who's from South Africa and was an important lawyer in the anti-apartheid movement in South Africa for a long time. Basically, the overarching conclusions that we found was that, in the first place, international law does have a clear prohibition on apartheid. It wasn't only limited to South Africa when international law prohibited apartheid in the 1970s. It didn't do it in a way that was only unique or specific to Southern Africa. It did so in a way that was universal and wanted to allow for any future iterations of that type of form of systematic discrimination to be outlawed and to be illegal. And so that's essentially what we have in Israel-Palestine today is a violation of that prohibition of apartheid. The studies that we've done kind of talk about the different components of what the definition of apartheid and the elements of it are. The essence of it really is that it's obviously a systematic, institutionalized and oppressive racial discrimination by one group for the purpose of domination over another group, and that's effected through law, through policy, through the institutions of the state. And so we have all of the elements there in the Israeli legal system, the way the constitutional order discriminates between different categories of citizens internally, discriminates between who can become citizens or not, who can migrate legally to Israel. And in the West Bank, we have a very clear, apartheid legal system where we have two separate sets of laws and two separate sets of courts, depending on which group you're from. So we have a military court system and a set of military legislation governing the Palestinians, whereas we have the civil law and civilian courts governing Israeli settlers in the same territory, and a whole very complex series of ways in which Israeli law is channeled to govern the settlements as a very distinct regime from the Palestinians. So there's been some progress on this in terms of pushing this in international law and institutions. The UN Special Rapporteurs, John Dugard first and then Richard Falk, did a lot of work in their reports to the UN to highlight this and explain it. The UN Committee on the Elimination of Racial Discrimination in 2012 said that Israel was in violation of Article 3 of the Racial Discrimination Convention, which is specifically about apartheid and racial segregation. They were limited or focused primarily on the occupied territory still, because that's the way the UN organises things. But we've had people's tribunals like the Russell Tribunal pushing forward the argument to show that this is relevant to the occupied territories, but also inside Israel and to the refugees. And last year we had the report from the UN ESQA commissioned report that found that Israel is exercising a single regime of apartheid over all Palestinians. We had obviously a big debacle in the UN then that came from a regional body, and the higher or the bigger apparatus of the UN did a lot of hand-wringing and disowned the report. The Secretary General of the Regional Commission that commissioned the report was forced to resign, and did so in a very principled way. And that was, a major, exposed in a major way the political dynamics within the UN, and how worried Israel and its allies are about this labelling and this terminology being applied because of the implications that it has symbolically, because of the resonance with apartheid South Africa, but also because of the gravity of the legal breaches and the crimes associated with apartheid. Just to note, last, what are we, May now? Yeah, so last month, Palestine, the Palestinian delegation in Geneva submitted a complaint to the UN Committee on the Elimination of Racial Discrimination against Israel, essentially charging Israel with violations of racial discrimination and segregation and apartheid. This is the first time ever within any of the UN human rights treaty committees that there's been what we call an interstate complaint filed to one state bringing a case for systemic human rights violations against another state. States are normally reluctant to do this because they don't want to turn it into a situation where, if they're calling out the violations of another country, that their own record will be called into question. So they tend to just engage individually with the committee rather than against each other. So this is quite a new departure. Israel now has 3 months to respond to that. We don't know if or whether or how they will respond, but it is a significant development. And the committee is, it's not the UN Security Council. It can't impose sanctions if it was to issue a judgment saying that Israel is guilty of apartheid or is an apartheid state, but it's, it has serious weight as a legal authority within the UN system, and can bring forward that argument in a way maybe that the kind of political intervention from the report last year wasn't able to do. The other thing, obviously, to note is that apartheid, as well as being a major violation of international law generally and of human rights, it's also a crime within the jurisdiction of the International Criminal Court. The International Criminal Court, as we know, has been engaged or asked to engage with the question of Palestine. So I'll maybe just say a little bit about that. Now, the International Criminal Court itself, as an institution, is in a kind of a legitimacy crisis at the moment, maybe bordering on an existential crisis. It was set up 20 years ago. It's opened investigations into crimes in 11 different countries, 10 of which are in Africa, and so there's been critiques of it which you can't really argue with, that it's essentially turned into a white man's court to prosecute Africans. And so it's been, there's been a suggestion that in some ways it's maybe looking for another situation or another investigation to give itself a way out of this challenge to its legitimacy. It's had about 40 plus cases ongoing over 20 years. It's only convicted 5 people so far, and it's been, very much dragging its heels on other situations that it's been asked to investigate, like the behaviour of British forces in Iraq or the situation in Afghanistan. And so we have, what seemed like an opportunity for the court to look at the question of Israel-Palestine and war crimes there, and take that forward as a progressive step for the court. But and there was a bit of hope or expectation around that a few years ago. Again, it seems to have stalled, and it seems that the court has decided it doesn't want the headache that getting involved in Israel-Palestine at the moment could create for it. It's obviously under a lot of pressure from other states not to do so. There was, I think, a quite telling statement from the prosecutor's office just recently during the march, the Gaza Return March, where within about the first week of the march, at that point, I think there'd been 27 civilians killed, more than 1,000 injured. The prosecutor issued a statement saying that she was keeping an eye on the situation there, and she said that violence against civilians could constitute crimes under the statute of the International Criminal Court, as could the use of civilian presence for the purpose of shielding military activities. And so we know obviously what happened with, in the first day or two of the marches, where initially the IDF spokesperson sent out a tweet saying that we arrived prepared and with precise reinforcements. Nothing was carried out uncontrolled, everything was accurate and measured, and we know where every bullet landed. And so with the documentation of the killing of civilians, that was essentially an admission of guilt of a war crime. And so they obviously had to backtrack from that, and the way they did so was to try and frame the situation as one of Hamas using the idea of a march as human shields, as a front for their military operations. That was very, obviously a false narrative that was trying to spin things, but the ICC prosecutor, essentially parroted that narrative and kind of used a lot of the unfortunately typical language of both sides should respect the law, etc., etc. And so that type of both sides false equivalence is what we see in a lot of the time in the statements of the Office of the Prosecutor, and doesn't, I suppose, give us a huge amount of faith in the court's ability to fully understand or address the reality of the imbalance of power and the imbalance in the ways in which violence is being implemented. So I suppose that what can we take from that? The Palestinian human rights organizations and international lawyers have been doing a lot of important work, filing documentation to the court, really extensively showing the extent of the crimes committed by Israeli forces in Palestine. That's very important work, I think, to keep doing. But at the same time, we need to appreciate the reality that we also can't wait for justice to be implemented from above, from international institutions that are subject to vested interest and power dynamics, and that we do have to at the same time keep pushing from below for the implementation of international law, from below, from the ground up. Omar talked a lot yesterday about the duties of non-recognition and non-assistance and so on, which was going to be my final point, so I won't reiterate too much of what he said, but I suppose just to make the point clearly that, beyond all of these individual human rights or international crimes or war crimes, all states have these duties under international law, not to recognise any illegal situation, not to render aid or assistance in maintaining that situation, and to cooperate to bring illegal situations to an end, right? So these are essentially kind of technical legal translations of what BDS is trying to do, essentially. The duty to not to recognise, not to render aid and assistance is the duty to boycott and divest, and the duty to cooperate to end violations is essentially the duty to impose sanctions. And we do have some historical precedent on this. The International Court of Justice, in the context of the apartheid South African occupation of Namibia, said that, what do these duties mean? They mean the duty to abstain from entering into economic and other forms of relationship or dealings with South Africa on behalf of or concerning Namibia, which may entrench its authority over the territory. And the judgment in that case gave us quite an elaborate account of what that means. It prohibits all economic, industrial or financial assistance in the form of gifts, loans, credits, advances or guarantees, or in any other form, right? So we have these duties that require legal action at every level, political, diplomatic and economic. We know, about how Israel is the biggest recipient of US aid, obviously, but also of EU research funding and huge amounts of commercial interaction and support. I'm coming up close to the end of my time now, so I'll just, I suppose, reiterate the importance of the conversation yesterday about, the fact that the EU, the European Union, can't dislocate the blame from its own inaction and its own complicity onto the UN veto, the US veto at the UN or other external factors. It hasn't had any problem imposing sanctions on Russia, which is a UN Security Council member, over its occupation of Crimea. So, its only excuse is its own complicity. And given the inaction and the complicity of the European Union, there's no reason that individual member states shouldn't be taking the lead on implementing these duties that we have. The proposed legislation that Francis Black has put forward in the Shannon now, seeking to ban the import and sale of goods from settlements and trade with occupied territories, that's, as was said yesterday, that's nothing radical or pioneering. That's the absolute minimum first step that should be taken towards all states fulfilling their legal obligations. Yeah, so but this obviously isn't going to happen on its own. It is the product of important sites of struggle at local councils, within our trade unions. All of these expressions of international law from below that we have that keep building the pressure towards a situation where the higher authorities have no excuse but to implement international law from above. And we know from the South African example that it took until 1977 before the UN Security Council imposed the mandatory arms embargo on South Africa. That was after nearly 30 years of localized boycotts and divestments around the world, and the movement building towards that. So I think I better leave it there. But I would just, I suppose, finish as well by emphasising that international law and human rights activism and this kind of stuff, it's only one element of the broader diversity of tactics that are needed in a situation like this. For anyone that is more interested in the legal aspects, I have a more long-winded academic version of what I've said, most of what I said today in a paper in the Palestine Yearbook of International Law called Anti-Colonial Legalities, Paradigms, Tactics and Strategies, which you can find online, or if you ask me, I'll give you a copy afterwards. Thanks very much.